Welcome to our Labour and Employment Law Update. In this edition, we are looking at mergers and acquisitions.
We'll highlight some of the key employment considerations for companies involved in transactions which could impact a European workforce.
As employment lawyers, we believe the first and most important rule is get employment lawyers involved at the very outset of any transaction. Seriously, while we might be biased when it comes to the assessment of the importance of employment-related risks and opportunities, we do believe that transactions almost always benefit from asking the right employment-related questions at a very early stage.
I'd echo that sentiment, Hanno. In some European jurisdictions, employment issues can influence how you structure the deal and the time it will take for the deal to close, as we'll see. So, what employment-related topics should parties to a transaction usually focus on?
The first and most obvious question is, how many employees are affected by the transaction and where are these employees located? The answer to this question will usually have an impact on the individual rights of employees impacted by the transaction, but most importantly, on so-called collective rights of employee representatives, which cannot be disregarded as employee representatives may have rather comprehensive rights and legal means to enforce these rights.
So it's important to understand whether there are trade unions or works councils who might need to be consulted. In some jurisdictions, works councils can have the right to co-determination procedures, which can delay the transaction, sometimes by several months.
Another decisive aspect is the type of the planned transaction. Are the parties planning to do share sale or an asset deal? Does the transaction qualify as a transformation of a business, for example, as the spin-off, carve-out or merger of businesses, which require the parties to consider specific laws on the transformation of companies, including regarding employees? Depending on the answer, the parties will need to consider whether a so-called transfer of business pursuant to the Acquired Rights Directive or TUPE legislation is given, which would lead to an automatic transfer of all employees in the business by operation of law to the buyer.
Much of the value in any business being acquired lies with key managers who've built the business and hold information that's critical to its future success. So it's important to have a good view early on about who's key to the business and how you can retain them. That might be through incentive arrangements, or it might be through restrictions that are designed to protect against those employees leaving and using confidential information for a competitive advantage. So let's hand over to the team for a deeper dive into these issues.
In the due diligence process, the following key points should be considered. Who are the key employees and what are their key terms of employment? In particular, their salary and benefit entitlements, notice periods, and whether or not they are subject to restrictive governance.
All employees in Europe will have written employment contracts, often based on a standard template, which we will need to review.
Does the company have pension plans or pension commitments? Especially unfounded pension liabilities can pose a significant financial burden.
We will also want to know if there is any pending employment litigation.
Last but not least, it is important to identify collective employment issues. Is there union activity or are employee representative bodies established? Is the company subject to collective bargaining agreements or shop agreements? These could, for example, restrict terminations or even oblige the company to maintain certain sites.
In addition, employee privacy issues should be considered at the outset of an M&A transaction. Data transfer agreements and NDAs should be executed which meet European data protection law requirements. Also, consider implementing means to restrict access to personal information where possible. This could be achieved by using clean rooms or by key coding or anonymizing certain personal information.
So when it comes to drafting the employment provisions in your transaction documents, the first step, of course, is to speak to your employment specialist. When you're acting for the buyer, you'll want to flush out any issues identified in the due diligence through warranties and, if necessary, indemnities. But there may also be other employment-related provisions in the transaction agreements, such as how you deal with employees during any period between signing and closing, and any employment-related conditions to closing, such as ensuring that all the key employees remain with the business up to and including closing. But that's only part of the issue.
Employment law considerations can significantly impact the timing and process of a transaction. For example, if an employee representative body is established, such as the Works Council, the employer may have comprehensive consultation and information obligations. If those obligations are triggered depends on the deal structure, the jurisdiction in which the employees are located, and the impact the transaction has on employees. A transaction may also lead to a transfer of employment relationship, a TUP, in which case employees must be informed beforehand about the change of employer.
So you'll need to consider addressing these information and consultation and any TUPE-related provisions in the transaction documents as well. And what about after closing? As a buyer, you may be looking to integrate the seller's workforce into your own, aligning benefits, or making other employment-related reorganizations. Again, this will trigger employment laws depending on the jurisdictions the employees are based in. And so in short, you will need to consider and closely adhere to employment laws before, during, and after closing of the transaction.